I am very excited to introduce our next speaker. This is a talk that I personally am looking forward to. I think there's a lot of us that can learn a tremendous amount from Justin here. So without further ado, this is Justin Okun. He is currently the senior counsel at DoorDash. So listen up, a lot of cool stuff coming.
I'm kind of shocked that anyone would want to voluntarily be part of this presentation, but thank you all for being here. I make clients go through this. Patrick and I work at DoorDash. I made him go through it. Maybe it's his revenge on all of you to make you go through it too. Has anyone ever heard of the term ACP? What does it stand for? You can stand up, you can shout it out. I can give you the microphone. You're like in my line of sight, so I apologize. It's a serious question. Like, does anyone know what's... Yeah, attorney-client privilege. So half of my clients don't even know that. So we're going to talk about it. It's a little different term in Canada. We'll also cover Australia as well. All right, here's my disclaimer. I am not your attorney here today. I am not going to give you legal advice. If you come at lunch and you want to tell me about your divorce or how you want to legally retaliate against your neighbor, I am not here to give that advice. You'd be surprised what people ask me one-on-one when they find out I'm an attorney. All right, I'm not going to, what did I say? I'm not speaking for DoorDash. All right, I am just my own opinions, and we're not going to get into like the do's and the don'ts. Because I'm not your attorney, I cannot tell you how to privilege things. If you're interested, you can see Google's Communicate with Care and what happened to them in an antitrust suit when they tried to create a whole bunch of do's and don'ts about privilege. All right, common law. There's a few exceptions, Quebec and Louisiana, but for the most part, when I'm talking about the United States, Canada, and Australia, I'm talking about common law, and attorney-client privilege comes from about the time of Elizabeth II, when the courts there said an attorney can't testify against their client. And that morphed in today, trying to keep things kind of super secret. I don't know how that happened. It's an evidentiary rule, basically. It just says if something is privileged, it's not going to be brought into evidence. Common claim is, let's say you're on trial for murder. You do not have to talk about what you told to your attorney. You know, you're just not going to be called up to say that. You wouldn't be called up anyway in the United States under the Fifth Amendment. But what it doesn't mean is that, again, something super secret. And in Canada, it's interesting, they've actually kind of, it's a quasi-constitutional right. They said it's fundamental to the system, privilege. All right, okay. So this is a Ninth Circuit case. Ninth Circuit covers the western part of the United States. It's one of the appeals courts. Came out with a big ruling on attorney-client privilege last year, or maybe the year before, I can't remember. It's a tax case where they tried to not have some tax documents go into evidence in a criminal trial, and they came out. Anyway, they lost the case. But you can see the definition. It protects confidential communications between attorneys and clients which are made for the purpose of giving legal advice. All right, when they did these court cases, they don't put them in bullet points, so I've done it for you. There's an attorney. You gotta have an attorney for attorney-client privilege. I cannot tell you the times I have gotten a document labeled ACP, and I'm the first attorney to ever see it. Probably not gonna be privileged at that point, right? Because there's no attorney. It's got to be a client. That's hard in a corporation. Why is it hard in the corporation? Because the corporation's the client. But not everybody in the corporation can be the client, right? It's kind of a, again, I'm not providing legal advice, but it's kind of a need to know, right? That is why, if you've ever dealt with attorneys, they were going to tell you, do not forward and send their legal advice throughout the company, right? That is going to go to the people who need to know, the client. It's got to be confidential, right? So it is not that this is some super secret, higher level classification, right? Confidential, a privileged document or a privileged communication is by its nature confidential. How do we make it confidential? What do you kind of do? If you've ever been around ACP, you must know it. You mark it ACP. But the marking itself does not make it ACP. It's just saying, this is something that's intended to be confidential. And now here's the hardest part. The purpose is legal advice. Right? So the dominant purpose, a primary purpose, or there's actually a debate, and I won't get into it, between the and a primary purpose. But let's just say a primary purpose has to be for legal advice, right? If it's just a communication between me and a client about how our day is going, or some facts you want to tell me, not privileged. Got to be for the purpose of legal advice. And if you have questions during this, please let me know. All right. Canada, they call it solicitor or legal advice privilege. You might have heard of it. And there's their definition, and it's the same thing. An attorney giving advice to a client. The intention is for it to be confidential, and the purpose is for legal advice. If you take away one thing from this talk today, those 4 bullet points. If you get those 4 bullet points, you're ahead of most attorneys probably, right? Attorney, client, confidential communication, the purpose is legal advice. Australia, same thing. They talk about common law, they call it legal professional privilege, and it's the same 4 elements. We call them elements in law, what makes it up. So a little insight into legal thinking. We do it by elements. If you tell me, is something X, let's say a data breach notification, is this personal information that we have to report? I am not sitting here formulating it like yes or no. I'm thinking about the elements. I'm thinking, is there unauthorized access? How do we define that? Is there personal information involved based on the definition of personal information? If I'm in Canada, I'm doing what? A significant risk of harm exception, right? That they have in Canada, Australia, and New Zealand. It's always based on elements, and it's the same thing with privilege. What are the elements? Do I have an attorney? Do I have a client? Is it confidential? Is the purpose legal advice? If I plug in those things, then it comes out privileged. It's the way every lawyer is going to think. That's why when you tell us facts, I'm giving you a blank stare trying to figure it out, and then I'm going to ask you a bunch of questions, because I got to break it down that way. All right. Now, there's a non-bolded part here, and that is because we're going to get into something you've never heard of, but is actually much more important for cybersecurity. It's called work product or litigation privilege. Australia's mushed it together into one, but we'll get to it. All right. And there, attorney work product. So, when you are preparing for trial as an attorney, your preparations, your mental processes, your notes, everything you're doing, you're getting from the client, that is also protected under what's called the work product doctrine. And there's called a but-for test. So when they determine whether you should have to turn this over, right? You're in trial, they say, bring me all X, Y, Z. You get from the other side's attorneys, I need all this information. You'll say objection, attorney work product, and maybe a judge will decide, and it says, your mental processes, I as your attorney preparing for litigation, this is my mental notes, my preparation, the other side doesn't get it. It would be unfair if during an adversarial process for the other side to get what the attorney's preparing for. It gets everything else, it gets facts, but not the mental notes and preparation. So there's attorney work product. If you have any questions, please let me know as we go through it. These are very difficult concepts. You're getting, years of law in like 50 minutes. All right. Canada, yes. Litigation, work product privilege. Again, same thing. Communications when the dominant purpose is litigation or when litigation is contemplated. Now, a lot of times people say, oh, it's work product coming in. Remember, you got to have a real dominant purpose of litigation, not, hey, we could get sued one day. No, it's got to be some real expectation of litigation. Same thing in Australia. We did this already for use in litigation or regulatory investigations or proceedings. So they got their legal professional privilege. All right, and what's the purpose? Here you got two quotes, one from the US Supreme Court, one from the Supreme Court of Canada. Our legal systems are based on the fact that you should have full and frank communications with your attorney, that you should feel free to talk with the attorney about your case and get your legal advice. If we didn't have that, people wouldn't tell their lawyers the truth. Most people don't tell me the truth anyway, but this kind of helps. So that's intrinsic to our system, and you can see here the Supreme Court of Canada, as I said, it's almost a quasi-constitutional right here. All right, but it's a narrow exception. So you can see the Ninth Circuit, Australia. It is not like you can turn everything into privilege. Everyone heard of a company called Merck? There's a case in the Eastern District of Louisiana where they said, due to their heavy regulatory environment and the fact that attorneys are involved in everything, everything was privileged. That did not fly with the court. It's called a case called In Re Vioxx. It's actually very interesting. If I, inspire one of you, look up that case, In Re Vioxx, and see what not to do. All right, facts are not privileged, right? So it's not like you can just say, oh, I've told my lawyer where I was on the night of the murder, so no one can ever ask me where I was on the night of the murder. No. You're not going to be forced to get up and say, what did you tell your attorney where you were on the night of the murder? But you can't be forced to come up and say, where were you on the night of, 28th of August, 1992 or whatever. So facts are not privileged. The communications to the attorney are privileged. All right. How am I doing on time? Okay. Now you have the entire law of work product, litigation privilege. You're experts. We're going to go through some cases. Has anyone heard of this case, In Re Capital One? All right. This was a huge case for cybersecurity law. It pains me when not one of you raises your hand. It's a very special case, but now you're going to know all about it. EDVA means the Eastern District of Virginia. Actually, the judge who made this ruling, I used to be their duty judge. I was once upon a time, it's called a special assistant U.S. attorney, and I worked with him. Capital One had an MSA with Mandiant for incident response services. Most of you should be familiar with this, right? Every year, they'd do a new statement of work, maybe a purchase order. The retainer was a business-critical expense. You can see the SOX senior manager said one purpose of the MSA was to ensure that Capital One could respond quickly, right? That's why you get a retainer from Mandiant, or CrowdStrike, I think, is here too. And even said, hey, we got to protect, we're a financial institution, we have to protect financial information. All right, so what happens here? They have a customer data breach in March. Takes them 4 months to confirm it. The very next day, what do? What's the most important thing you can do once you've confirmed a breach? You call outside counsel. Not really, but I like that you all nodded yes. Within a few days later, outside counsel and Mandiant signed a letter of agreement, and they just brought it under the Capital One Mandiant MSA and the statement of work, right? They announced it a few days later. Many lawsuits were filed, right? So there was an agreement between Mandiant and Capital One. They had an IR retainer, came out of the cyber budget, and then the lawyers came in and said, we have a letter of agreement, now it's between Mandiant and this outside counsel under the terms of the other agreement. Probably because they wanted the SLA, maybe, I don't know, it's a day later. And so the incident report comes out, right? On the 4th of September, Mandiant issues a report. They pay the retainer. Someone kind of gets wind of something happening, and they redesignate it as a legal expense in December. All right, and then they send the report to the legal department, the entire legal department, 4 regulators, Ernst & Young, their financial auditor. They said it was to be used for SOX disclosures, and another, what they call a second-line business need. Okay. How many people think, now that you're all experts, you just raise your hand based on privilege, that this was a privileged report, Mandiant? You're all right. In fact, they didn't even assert it. They didn't assert privilege, they assert work product. That's why I said work product's probably more important for you. And the court you hear says here, you know, the determinant issue is whether the mandate report would have been prepared in substantially similar form but for the prospect of litigation. How many people here think the mandate report would have been prepared, would not have been prepared but for litigation? Anyone? That's what the court said. You're all right. Just by keeping your hand down, you were correct. Next time we'll mix it up. All right? So the court just looked at this and said, they were going to do this anyway. You just inserted an attorney in to the process. And in fact, the outside counsel was not involved. Anyone here been in an incident response where the attorney is actually involved, asking questions? All right, that's what you want your attorney to do, right? Because if the attorney is sitting there not doing anything, you're going to end up kind of like Capital One, right? And the retainer was business critical expense. That didn't work. The judge said, you know, providing it to the regulators. It's not privilege. So remember, privilege was you got to keep it confidential. But the fact that you're sharing it with other outside parties, probably not work product to prepare for litigation. And it was used for SOX and referenced in the FAQs. All right, so attorney work product did not apply. How fast does everyone think Capital One settled? I think it was the next. Well, they appealed to a district judge. The district judge knocked them down, and then they settled because these reports are not meant to come out. Now, most companies have changed the way they do this. A lot of outside counsel have direct agreements now with Mandiant, with CrowdStrike, MSAs in place. So it's changed in the United States because of that. Anyone heard of this case? Yeah, you heard of it? Yeah, it was a big breach, personal health information. I didn't know about Life Labs until I read about the case. But they hold personal information, personal health information. Ransomware attack happened. I hired outside consultants, you know, and they had, I think most of the customers were in Ontario and the British Columbia. So those information privacy commissioners launched a joint investigation. And it's a little different here because it went to the privacy commissioners to determine if the reports were privileged or not, which in the United States it would be a decision by the judge, but it went there and then it was appealed to the court in Ontario. All right. So the IR report, described how the attack occurred. They wanted emails. There were a whole bunch of documents that the privacy commissioners wanted. How many people think, you know, they're entitled to this? Are the information privacy commissioners entitled to this information? Yes? I tricked you this time. You're all wrong. All right, look at the Personal Health Information Protection Act says custodians have to investigate, they have to remediate, and it authorizes the IPC to make you do things. If that is the case, if you are required to investigate, contain, remediate, if you're required to listen to the IPC, can you say that the documents you created to do so, or the report you created to do so, is privileged? We'll try a yes if your hands. No. No. Go back. Yeah, no. They lost. Lost across the board. Life Labs, they had to give over the reports. They'd already given over to the information privacy commissioners. You cannot say, and another example of this is like a risk assessment. So if you're in California now, there's new regulations for cybersecurity on risk assessments, right? You have to do a risk assessment. Because it's a statutory duty to do so, you cannot then say, oh, this is privileged, I'm not going to hand it over. You're required to hand it over. And you think about it, it would undermine the purpose. So a lot of these things that you might say, the attorney directed me to do it. No, you have a statutory duty to do so, you have to do it. And this is what happened here. Anyone heard of this breach? Singtel, Optus, no, in Australia. All right, so I don't even know actually what Optus does, but I know they had a big breach. 9.5 million customers PI. All right, the general counsel's made aware. Treat your general counsel better. Don't tell him a few days after it, or her. This is not what I want to see, that they, there's a data breach, happens a few days, and then you tell the general counsel. So he freaks out, and he's already thinking, there's actually testimony from him, or he gave a declaration where he's like, I knew we were in trouble. I knew we would have to face litigation, and he was not wrong. All right, so the general counsel retains outside counsel. Optus announces the breach a few days later. It's pretty quick, and sure enough, the general counsel's right. They get hit with regulatory investigations in Australia. They get hit with class action lawsuits. Blood's in the water. The sharks are coming, right? All right, and the general counsel, he does the right thing. He says, we're going to retain Deloitte. We're going to do it. They got to assess the risk. Optus publicly announces that Deloitte is appointed, I'll read this, to conduct an independent external review of the recent cyber attacks and its security system controls and processes. I am assuming many people have seen, after a breach, where they come out and say, we have retained a world-class third-party forensics expert to get to the bottom of this. And of course, you never hear what the bottom of this was, but they retained the third-party expert to get to the bottom of this. All right? This was not a good move if you want to keep it privileged, and we'll get to why. But they did it. They made a big announcement from the CEO, who, by the way, is no longer the CEO of that company, but at the time she was. All right? So the outside counsel retains Deloitte. They must have looked at something from the case in the US. We know that in the Canada case, they actually followed the Capital One case. They actually cited to it as persuasive authority. So these guys know, hey, we're not going to retain Deloitte directly. Outside counsel is going to retain Deloitte. All right, and they give them guidance on privilege, how to do it. All right. So the general counsel says, hey, there were multiple purposes. Legal advice in anticipation of litigation. We're going to identify the root cause of the attack for management. We're going to review our policies and processes in relation to cyber risk, right? So in the US, they would call this a dual purpose report. That means it has a business purpose and a legal purpose. You've all just heard what I said about privilege and how it has to have a dominant legal purpose or a primary legal purpose. Very hard argument to make if you have multiple purposes to say the first one here, legal advice in anticipation of litigation, is the dominant or primary purpose of the report. They made that argument. Anyone know about the Target breach from years ago? Yeah, they did a dual track investigation. I'm not going to get into it here, but they had their incident response team in-house doing one report, responding to the incident. They had a different team of outside firm, I can't remember which firm it was, doing another report, and they didn't mix it, and that report that was prepared for the legal team was privileged. And it's kind of the gold standard, I would say, of how to do it, but most people don't want it, right? You're in a company, we want to share the information, we want different purposes, but it puts some of this privileged stuff at risk. Anyway, so the judge, the primary judge here, said Optus did not adduce focused and specific evidence, I love these terms, that the legal purpose was the predominant purpose. So there was nothing there that said the predominant purpose was number one, legal advice in anticipation of litigation. Now, when the CEO put this out, and with their, I'm sure with their comms team, the comms team loves to put this stuff out. We're going to get to the bottom of this. I'm committed to rebuilding trust. All right? She sunk the privilege argument. she put a knife through the hearts of the attorneys there, right? Probably didn't think about it at the time. And it shows the kind of a tension, if you will. You know, if you're responding to an incident, you're part of the cybersecurity team or information security team, you're probably not thinking about this. How many people are incident responders here, by raise of hands? There's a few. When it gets to the point of comms, are you involved in that discussion? A little bit. Yeah, it's a weird thing in incident response is that, you know, you get the firefighters in there, they send stuff up, and then when they make these decisions, you know, it's comms, maybe a product person, and it's just, it goes from like technical to like, what can we do to make ourselves look good? And the CEO wanted to look good. I don't know if it was the right choice. She doesn't have a job. The report came out, right? Because you can see at the bottom from the judge, the words attributed to the CEO manifested a dominant purpose which was other than legal advice or litigation purpose. So when you get to that point where the comms are sending it out, they run it by the attorneys. Maybe they did, maybe they didn't hear. But they probably made some calculation, I don't know, that it was worth it. That we got to build trust with our public, our customers, and this is what's going to work. But it sunk the report. By the way, Cambridge Analytica, was that Facebook, right? Same thing. They said, we got a third-party forensic firm that's going to help us with everything, and they lost in Massachusetts court when they tried to make their report privileged. It all came out. So if you're going out there saying, hey, we're going to build trust, we got a third-party forensic firm to get to the bottom of it, we're going to do all this stuff, you are telling the world, we're not doing this for a primary legal purpose. Might want to keep it separate. All right. How much time we got? Okay. So, okay. Now you've been a okay audience, but we're gonna actually be a little more back and forth. All right. This works, right? This works. All right. Like, who am I going to get here? Who am I going to get here? It's a little too loud. You have what you think is maybe an incident. You see some personal information in there. You Slack your attorney, maybe on a channel. You want to get some, advice. It's a public channel. Is it privileged? Who said that? All right, well, why?
You didn't limit the audience to the need to know.
Oh my God. I wish you were my client. Thank you. That's perfect. All right. You're doing a risk assessment. You want it secret. You don't want it ever to come out, this thing called ACP. You market ACP. You include the people that should know. Who should be on there? You're looking intently. Who should be on that? Okay. The A in ACP, right? Yeah. You got to have the A in ACP. If you don't have the A in ACP, no ACP. So have the A, all right? And then what do you think, you do with the A? Do you just CC the A? What do you think? Do you CC the A?
No, you have to address it directly.
Have you been trained by someone? All right, yeah, you have to actually, it has to be a 2. There are actually plenty of cases that say merely copying an attorney does not work, right? Right, because remember, there's 4 elements. If you include the attorney, but it's not to the attorney, are you really seeking legal advice? No. And the ACP is just the confidential one. Remember, the purpose has to be legal advice, right? I cannot tell you how many emails I've had in my career from companies that will go unnamed and people that will go unnamed, where they say, adding Justin for privilege. And I want to hide my head and tell them, this just made it not privileged, because when a judge sees this, they're going to say, you're trying to create a hoax, right? So when the judges look at this, and let's say the US, they do what's called an in-camera review. So we'll get a discovery request in the US. They'll say, give us an incident reports and blah, blah, blah information, right? We'll write an objection. The objection will say back, objection, privileged. But that's not enough. It's not just the word of the company to say it's privileged there. You have to do what's called a log, which says kind of what the information is. So not exactly, but just describes what it is. And then the judge looks at it in camera and says, is it or is it not? And if the judge sees something that says, adding Justin for privilege, it probably is not going to fly unless you're really getting the legal advice, right? And we've also seen cases, I think it's Google, Facebook, bigger cases, where maybe they've added the attorney, but the attorney is silent. It's called a silent attorney. It was Google. It's Google's antitrust case. And it doesn't work, right? The attorney's got to be involved. So the attorney has to be a big A, not a little a, right? Okay. Let's say you seek attorney's advice. It's a email, let's say email. There's a client, there's people that need to know, but you didn't mark it privileged. Right? There's nothing that didn't mark it privileged. Is it privileged? You don't know, all right. You didn't mark it privileged. Do you know? You're getting the full legal effect. So in at least in American law schools, they do the Socratic method where you get called on. And so I want you all to experience the 3 years of misery I had to experience too. The fact that you have not marked it is not dispositive, right? It is just an indicia, the marking of confidentiality. If you send me, if Patrick sends me, let's say, a direct Slack, and we can kind of see, hey, he's asking for legal advice, he doesn't have to say ACP every time, right? I see a lot of emails sometimes where it's like every single one, ACP, ACP, ACP. Hint, just put it in the subject line. Now, the practicality of it is not everything you do, all communications between an attorney or not, are necessarily privileged, right? It's not like the whole document is not going to show up. You'll redact portions of it. So as a practical matter, that marking helps us actually in discovery, right? Got trillions and trillions of documents, tons of data. I can put that in a special pile for your e-discovery. Does anyone do e-discovery, been involved in e-discovery forensics? All right, so it goes in a special pile, then we review that separately. All right. A report is made. I'm going to head over that way, but let's say an incident report is made, an investigation report. Kroll, someone's been retained. They did it right. The outside counsel retained it. The firm, the forensics firm, the report has been kept to like the CISO, a few members of the incident response team, maybe your legal team has looked at it, the people that need to know. Now your communications team comes over and says, we'd like to see the report too. We want to create some FAQs. You know, we want to know what you did and what you didn't do. You use the report to create some FAQs. You're right by me. Does that keep the report privileged? Your comms team is using it to make some FAQs.
I don't think so. No.
Probably not, right? Because you're using it now for a different purpose. It might have been a primary purpose before to give some legal advice, but it's not now, right? I say probably not because you could say, hey, this was a minor purpose to it. It was helping out. But for the most part, you're probably syncing it. So you got to keep that report tight, right? So let's say there's a report, incident response report. It's put together. It's done for legal, advice for the outside counsel. You share this report with the entire security team, right? You're remediating, everyone's got to need to know, there's a post-mortem, right? Everyone's got to know. Is it still privileged?
Just have one question for you.
Yeah.
You said to be under the claims of the ACP, it's important to get an attorney inside the case. The point is, usually when we are facing an incident, we are required to also work with the breach codes, which usually they are attorney, but they are specific to work on the incident. So they are breach codes. So can we be under the ACP by using a breach code because it's an attorney, or is there a difference between the two?
What do you mean by the breach code?
Okay. When you get in an incident, some will work often with your insurance. You will
Okay, so the one that's on the panel where they say, here's what you immediately should call. Yeah, so their attorney's giving you advice.
Okay.
There are some nuances when working with insurance because the insurance is not the client. Ask your attorney about that. Again, that's an area where we're veering into me giving some legal advice, but think about it as a whole, like the insurance company is not the client. It raises a lot of concerns with insurance. But assuming the insurance isn't involved and it's just you talking with this attorney and you've created a relationship with that attorney, yeah, it's privileged. It's the attorneys involved.
Okay, if we are working with a breach coach, okay, so it's supposed to be an attorney, and it's come with the insurance, because it's a contract, it's not a client. We are the client, so there is no protection under ACP by using the attorney. It's coming from the insurance part.
So there should be. There could be, okay. Right? So an attorney-client relationship can be formed at any point, even if it's kind of strange the way it's set up and not a retainer, and so it could be. So one of the cases we talked about here where I said, hey, what the attorney-client privilege was called upjohn, let's say, in the United States, right? And if anyone's ever been in trouble with a company and you've been interviewed, you might have gotten an upjohn warning. And that is because you have to tell everyone there an attorney-client relationship isn't formed. So yours is very fact-specific, and you would want to look at that and see if an attorney-client relationship was formed. Good job making me forget my entire question.
Thanks.
I don't even remember what I asked now. Yeah. You share the report with the entire security team. Is it privileged? Could be, right? It depends on your team. If you got a team of hundreds of security team members, maybe not. Maybe they don't all have a need to know. If you have a small team of 5, maybe they all have a need to know because they're going to do some work with it. All right, how much time do I got, Patrick? All right, cool. Not cool for you, but cool for me. All right, you have a report. You want to move now into remediation. What I like to do is give it to the GRC team. Hey, here's some tasks that we have to do. They pull out a full remediation plan, right? And they're going to go out to the engineers and other people in the team, and they're going to fix all these problems. And they come to me and they say, we need the report. We're going to use it for this. Is it a privilege?
I'm guessing it's not anymore if it's used for something else.
You've learned. Yes, it is likely not. So, you're probably all asking me, well, hold on. You have this great report. It tells you all, CrowdStrike's here, right? All right, they did a great report. It's the best forensics report of all time. You need to use this to fix the problems, right? And you, attorney, are telling me I cannot use this great CrowdStrike report that, of course, came out of the legal budget to fix these problems? This is the stupidest thing I've ever heard. Well, presumably, you only need the engineers to know what to do, right? Do they necessarily need to know everything about the root cause? Probably not. Remember, facts aren't privileged, right? So facts, things to do in response are not privileged. You can parse this stuff out, right? But what you don't want to do is what they kind of did, let's say, with the Capital One case, which is send it to everyone in the company and go, use the report as is. You got to keep it to need to know, right?
What about if the ACP becomes part of a leak? Is it still privileged, or because it's becoming public? How does it stand?
The privileged documents have got out?
Yeah.
Oh my God, my nightmare. My nightmare. By the way, I have actually dealt with law firms who've had breaches. All right, so here's where privilege and confidentiality is kind of different, actually. Privilege would be maintained, right? Assuming the attorneys took the proper, protocols, it doesn't have to be perfect, then yeah, it would still be privileged. It would be called a clawback. It wouldn't come into evidence, most likely, right? Now, if the attorneys we have to upload it to the attorneys, right? You have to use Box sometimes. They're not, that's technically savvy, these law firms. If they were to keep a link open, such as it was open to the public, probably wouldn't be. They didn't take the efforts or the reasonable precautions to keep it confidential. So it goes to that confidentiality thing. Did they make reasonable efforts to keep it confidential? All right, so here's a good question then. Next one, I'll go down this way. Yes, you have a question.
Great session. Is there a distinction in law between internal counsel, general counsel, and outside counsel? And second part of the question is, structure, big picture, should you retain outside counsel a priori in anticipation of needing outside counsel in the event of a breach?
Great questions. Yes, I am a lesser counsel as an in-house counsel. It is not presumed that the advice I'm giving is legal advice because so many in-house counsel give business advice. There are cases about that, and in both the Australian and Canadian cases as well, it said we'll more strictly scrutinize the advice or the communications coming from in-house counsel, whereas we'll presume that outside counsel is privileged. If you were to go to the EU, and I have actually a second law degree in EU law, in-house communications, nope. They are not even going to be privileged for the most part. You have to retain the outside counsel. So there is a distinction. And the second part, I forgot the second part.
Should you retain outside counsel from the get-go?
Assuming I wasn't giving legal advice, I would say yes. So that's probably a good idea to have a retainer with outside counsel so that they can be, on the spot. And probably you want to check that that outside counsel has their own retainer agreement with a forensics firm. Would be a good.
So you would subcontract the forensics firm through outside counsel. So that's the structure.
Let's not say subcontract, but that's you got the structure. All right, you got the structure. Let's not say subcontract.
Okay.
All right, that firm is providing advice to the outside counsel. 5 minutes. All right, then we'll do one or two more questions. All right. Incident. You're running it through JIRA, right? You're putting all the stuff about the incident in JIRA. People can see it. You're laughing, so I'm going to ask you. No? You're putting it through JIRA, all your incident response stuff. You even take your attorney's communications from Slack and cut and paste it right into JIRA. Is that privilege?
No.
All right, why do we say depends?
Depends on the access, the team that has access to that JIRA information. Did you set that up with the same restrictions as your original ACP documentation, or did you leave it wide open?
All right, we got an A+ student here. Someone who knows what they're doing. Yes, there are actually cases about this on JIRA involving Atlassian, where the courts have said, there's one in San Diego, that it was privileged. It doesn't have to be that an admin can get in there. As long as something was made, the precautions were put in there such that it is confidential for the most part, JIRA will work. What you don't want to do is make it open to the entire company, right? You make it open to the entire company, it's not going to last.
I've got a question. If you got, let's say, 2 or 3 extra people let's say if you got 2 or 3 extra people in that JIRA, that would not be within the ACP usually. Could that make the ACP go away, or there's a, leeway in there?
If they don't have a need to know, kick them out. Take no prisoners. I'm telling you, if you want to make it privileged, kick them out. I kick them out. People get upset, right? Better to be upset early on than to be upset like Capital One or someone else where they look and say, hey, there's no privilege. Yeah, kick them out. All right. We got 2 more minutes? 4 more minutes. All right. Let's say, I'll go back down this way. Let's say I have a report. It comes from outside counsel. It's all set up right. As outside counsel does the report, I'll say Kroll gives them the report. They write down all the things you should do, and then you don't do them, right? You just don't. Someone said, whatever, we're not going to do them. And the report, for some reason, is determined not privileged. What kind of shape are you in at that point? I'll ask you right here.
Okay, yes. I don't know.
All right. You're in a bad way, right? Because the report is not privileged and you didn't do what they said, right? There's no record of it. This happens actually more often than not because people think it's privileged. And I like to end on this example. Don't assume that something is going to be privileged just because it is, right? Don't say things like, there's a horrible breach, we're a terrible company, we're all going to die. You'd be surprised what things that I'll see in these reports, right? Similarly, if you're asking for remediation steps or things you can do to fix it, the company should do it, right? Because if it comes out later that you didn't do it, that is bad, right? So think about what you're asking from the forensics company when they do it. Assume it won't be privileged, that it will come out, and how will it look later? And I say that to you as the teams of cybersecurity, because by the time it gets to the comms teams, by the time it gets to people who don't know anything about this, they're just trusting that this report is right, that this is what they can rely on, that they can create media stories about this, that they can say things like, we mitigated, we remediated, it's all done, you can trust us as customers. If it's in there that's something you have to do it, right? Don't treat it as like superfluous. Right? That's more important actually than maintaining privilege, is just using the report. Don't say crazy stuff in the report or risk assessment or whatever you think. Don't rely on the privilege necessarily. Assume it won't be maintained, right? We have 3 big companies right here with lots of lawyers and it wasn't maintained. Assume it wasn't maintained and do the report and look it over that way for your bosses, for all the non-security people who are relying on you and cannot read this. I'm going to tell you, when I have presented these reports to a general counsel, to a comms team, to anyone who's non-security, even sometimes engineers, I might as well be speaking in Greek. They do not understand it. All they want to know was it fixed? And we did the perfect thing so we can say we did it, and they're depending on you to confirm that, right? And so if you're actually saying this is terrible in Slacks, it's a problem. By the way, last comment. Someone said they did e-discovery. Was it you? E-discovery? We can grab all your Slacks, right? Don't think that those Slacks are safe. In fact, many of you may waive privilege with your separate Slacks that are a gut punch to me if you were involved in an incident response. Don't create separate Slacks saying, the CISO's stupid, the lawyer's getting in the way, all those things. I hate this place. I knew this would happen. You cannot imagine how many of these things we actually pull where people think this communication. And don't now move to Signal. All right, there's some companies now getting in trouble, the last point, where they're using, the execs and people in your team are using, ephemeral messaging, they're using their own personal devices. We will grab those devices. I actually had a senior director of cybersecurity freak out because we had to grab his phone. He didn't want his phone. I said, it's either us or the FBI. So we pulled his phone. Don't communicate with your forensics firms or anyone else on Signal, WhatsApp, or anything else. Keep it on Slack. Put the attorney in there. You'll be safe. Thank you all. I appreciate it.